everyone. I'm Ben Young. As Jen mentioned, I'm a partner with the law firm of Jeffer Mangels, Butler, and Mitchell. I'm a bankruptcy lawyer, and I specialize in insolvency matters for mid-sized businesses, middle market companies. So I handle complex matters that involving distressed middle market companies. A lot of bankruptcies, a lot of workouts, restructurings, assignments for the benefit of creditors, matters of those type. And so I wanted to talk today about some of the issues that small businesses should know about, some of the things that small businesses should know in these unprecedented times, because there have been a lot of changes in the law and in various actions that the courts have taken to deal with the financial crisis driven by the coronavirus. So what I want to talk about first will be the emergency moratoriums that the California courts have put in place. And then I want to talk about the expansion of the Federal Small Business Reorganization Act that was part of the CARES Act, which I think is an important piece for small businesses. And then I want to just briefly mention that a lot of the local courts are closed, as many of you who are lawyers probably know, which has some impacts as well. So first, with respect to the emergency rules the courts have enacted, the Chief Justice of the Supreme Court issued of the California Supreme Court issued an emergency rule that basically bans unlawful detainer actions, residential or commercial, statewide, except if there's a public health or safety issue involved. So this just puts the brakes on any kind of eviction action that a landlord might want to take against a commercial tenant that's unable to pay rent due to the virus. What's interesting is the duration of the ban. It's a 90-day. It's 90 days after the governor declares the end of the state of emergency. And it's very unclear when the state of emergency is going to end. It could well be extended. It could go for a long period of time. And then the ban on unlawful detainer actions is going to go on for 90 days after whenever the governor declares the state of emergency at an end. So this could be with us for quite a while, and that's an issue for commercial property owners. It's also an issue for tenants to be thinking about. The second emergency rule that the court came out with was to basically ban judicial foreclosure actions. Judicial foreclosure proceedings are now stayed, again, until 90 days after the governor declares the end of the state of emergency. There's also the public health or safety exception. But this basically puts the brakes on all judicial foreclosure proceedings. And we'll talk in a minute that doesn't encompass as many foreclosures as you might think. And in fact, it probably doesn't capture very many at all because most foreclosures in California are not done judicially. And it also only appears to apply to real property foreclosures, not to a judicial action to foreclose on personal property. So this one may be somewhat limited. But again, we have the same issues with duration, 90 days after the governor declares the end of the emergency. Now, there's a couple important points to note, and I think Jen alluded to one of them. These are moratoriums. They're only a delay in the exercise of rights. It's the can kicked down the road, potentially for a long time, but there's no forgiveness and there's no repayment schedule. So once the moratorium ends, the money's owed and the creditor is going to have the right to exercise whatever rights they might have. So if a tenant, for example, doesn't pay rent for a long period of time and then the governor declares the emergency over, in 90 days, that tenant's going to have to come up with a significant chunk of money or be at risk of an eviction proceeding at that time. So it's helpful in the short term, but without a repayment schedule, there's a cliff at the end of this. The other issue that's a little unclear is what happens with late charges or default interest. neither of these rules mention either of those. So it is possible that a landlord or a lender could insist on late charges or default interest for whatever payments aren't made during the course of the moratorium. And we'll talk about this a little later, but it seems to me that with both of these, what they do is force the lender and the borrower, or the tenant and the landlord, to talk to one another. The tenant has some protections, the borrower has some protections, but the money is still owed and it's still going to have to be paid at some point. Obviously, the lender or the landlord has incentives to get the cash flow going. So there's definitely an incentive for both parties to try and work together and come up with their own solution. Another important limitation is that the foreclosure bar applies only to judicial foreclosure on real property. As I mentioned, most foreclosures in California are done through a private procedure with a notice of default, or NOD. And there's no bar to a lender proceeding through that process. Now, I guess one could ask a question of how that really could be done, how one could conduct a foreclosure sale if there's a ban on any gathering of more than 10 people. The idea of a foreclosure sale is an auction that is supposed to be well attended. And there's also issues with how can due diligence on the property be done. So there's a question of whether one could really do that as a lender, but certainly they have the right to proceed with an NOD if they elected to do so. There's also no bar to a foreclosure on personal property, either judicially or through a private sale process under the Uniform Commercial Code. I guess a question would be, again, if one was trying to proceed in a private foreclosure sale on personal property under the Commercial Code, there's an obligation to proceed in a commercially reasonable fashion. And is a sale in these times commercially reasonable? Is it possible to do that? I imagine you could have an online auction and have some kind of online process, but how would parties do their due diligence? How would they go and look at whatever it is that's going to be sold? And a last practical impact is whether a lender can get a receiver appointed. As many of you know, one of the reasons judicial foreclosure proceedings are brought is so a lender can get a receiver appointed to collect the rents from a distressed piece of property. And if there is a stay on judicial foreclosure actions, can a lender file such an action and get a receiver appointed? There may be some workarounds in terms of how you actually plead it, but and it may depend on how broadly the courts and the clerk's office view these rules. But I think there is very much a question mark as to whether a lender with a loan in default, whether they can get a receiver appointed, which would be one of their traditional remedies. There also are a number of local moratoriums that have been enacted by cities and counties throughout the state. I didn't want to go through all of those because there's great variety and a large number of them, and it's very local. But I thought the Oakland eviction moratorium was interesting because it seems to go farther than any of the others that I've seen. Oakland has adopted a moratorium on commercial evictions, and the ordinance provides that a small business tenant cannot be evicted ever for non-payment of rent that became due during the emergency if the non-payment resulted from a decline in business as a result of the emergency. And they specifically state that the tenant's not relieved of the obligation to pay rent, but they can never be evicted. They have an absolute defense under the terms of the ordinance to an eviction action if the non-payment resulted from a decline in business as a result of the shutdown. And small business here means 100 or fewer employees and 15 million or less in revenue. So a decent sized company, not a huge company, but a decent sized company. And so it'd be interesting to see how that plays out. If a landlord can't ever evict the tenant for non-payment, but the tenant still owes the money, it could be interesting in seeing how that plays out. But I think this is a very important protection for tenants in Oakland at least, that goes well beyond the moratorium and the emergency rule that the court has put in place. And as I mentioned, the local courts, the state courts are temporarily closed. The exact date when they're scheduled to reopen varies county by county. I would expect many of those dates are going to get pushed out depending on the speed at which the state reopens. But I think the courts are likely to remain closed. I think they're scheduled to be closed in most cases through May, and I would expect those dates to be pushed out. As a practical matter, this is a moratorium on payment of debts, because if you can't be sued to collect the debt because the court's closed, then effectively you have a moratorium, at least until the courts reopen. The federal courts do remain open. I've had a number of hearings in the bankruptcy court in the last month. Those remain open. Everything is being done telephonically. No one can go to the courthouse, and the hearings are conducted telephonically. All trials have been postponed. Anything that requires live witness testimony has essentially been postponed. But law and motion matters are proceeding, which is useful in bankruptcy cases because you often have to go to court and get various matters approved by the judge in order for the business to continue. So now I'd like to turn to the Small Business Reorganization Act that was recently expanded, as I mentioned, by the CARES Act. This is a bill that was enacted by Congress last fall and became effective in February, I believe, just coincidentally. The reason for it is that Chapter 11 is very expensive and often, as a result, not real practical for small businesses. The cure can be worse than the disease because the legal fees in a Chapter 11 case, particularly if it's contested, can be tremendous. And so to address this and to make Chapter 11 more practical for small business, Congress enacted a streamlined version available only to small businesses. It was modeled on Chapter 13, which is the bankruptcy chapter for wage earners, and we'll talk about that in a minute. And as originally enacted, there was a debt cap of $2.5 million. So a business with total debt of $2.5 million was eligible for this procedure. And what it allowed was in the normal Chapter 11, if it's very expensive, many small businesses would wind up being liquidated because they just couldn't afford the legal fees. This bill would give a small business a chance at reorganizing itself without incurring those kind of legal fees and continuing in business. But with the debt cap of $2.5 million, it didn't apply to that many businesses. So one of the things that was done in the CARES Act was to expand the Small Business Reorganization Act by raising the debt cap to $7.5 million. Again, this is total debt, so it's secured and unsecured debt, whatever is owed by the business. But if the small business has a debt of less than $7.5 million, then the SBRA is going to be available to it. And the key provisions of the Small Business Reorganization Act is, first of all, just as in a normal Chapter 11, the debtor remains in possession. There's no trustee appointed. So the debtor remains in control, can operate the business. There are provisions for removing the debtor if the debtor has been a bad boy or a bad girl. They can be removed and a trustee appointed. But just like in a Chapter 11 case, the presumption is that the debtor will remain in possession and operate the business and manage the reorganization process. Secondly, only the debtor can file a plan. Creditors cannot file a plan, so the debtor controls the process, which is huge in a Chapter 11. The debtor, however, must file a plan within 90 days. You can't file one of these cases and sit there forever. You have to get a move on and file your plan within 90 days. There is a very simplified disclosure statement that is used in these small business cases. And that's important because preparation of the disclosure statement is a very large item of expense in a Chapter 11 case. And another big point, and I think this is one of the main ones, is that creditor acceptance is not required to confirm the plan in the small business case. And let me explain why that's important. In a normal Chapter 11 case, the debtor prepares a plan and a disclosure statement, and those documents are sent out to creditors, and creditors vote on whether to accept or reject the plan. Creditors vote by classes, and you have to get at least one class of your creditors to accept your plan. And the purpose of the disclosure statement is to provide adequate information to creditors so they can effectively vote. And that's where a lot of the expense comes in, because a fairly detailed disclosure statement has to be prepared so creditors can vote on the plan. And so you end up with something that looks a lot like an offering memorandum, and the cost of preparing that can be quite high. In the small business case, there's a much simplified form, and while the debtor can proceed through the voting process if it wants to, it doesn't have to. It doesn't have to get creditor acceptance. It doesn't have to have the creditors vote to confirm the plan. One of the issues with creditor voting and confirmation is that if creditors vote to reject the plan, then shareholders basically get wiped out. In a small business, the shareholder is generally the owner of the business. So either the owner of the business has to come to an agreement with creditors and get them to vote to accept the plan, or the shareholder basically gets frozen out. And so that's why a lot of those cases wound up in liquidation, because the business owner couldn't come to agreement with his creditors. Now, in the Small Business Act, you can confirm the plan without the creditor acceptance if the debtor puts all of its projected net disposable income over the next 3 years and uses those funds to pay creditors. And the court has the discretion to increase that period to up to 5 years. Presumption's 3, it can be increased to 5. So if the small business debtor puts on the table all of its projected net income for the disposable income for the next 3 years, the court can confirm the plan without creditors really having any say-so in it. They don't have a vote. And disposable income is the income of the business less the expenditures necessary for the continuation, preservation, or operation of the business. Now, these terms aren't defined in the Act, and I would suspect there's going to be a lot of litigation over what exactly those terms mean. I think one of the issues would be in a business, can you have capital expenditures? Can you have reserves for expenses that you expect to incur in the future? Various things like that. Obviously, from the business owner's perspective, you're going to want to push the disposable income down as much as you can so that you pay as little as possible to creditors. I think certainly the business owner would be able to take a salary for services actually rendered, as long as it's market-based. That should be fine. And I would think that some level of CapEx and other expenses that are not direct operating costs would be permissible. But I think there's going to be some fights over that. But if the business puts on the table, as I said, its projected net disposable income, then it can get the plan confirmed without creditors having any right to vote on it. Another important point is that the plan can be modified only by the debtor. Creditors do not have the right to modify the plan. And remember, we're talking about projected disposable income over the next 3 years. The debtor has to pay the projected net disposable income to its creditors. What happens if actual income is less than projected? The statute provides that the debtor may be able to modify the plan to reduce its payments at that point. So if you do worse than projected, then you may be able to modify the plan and reduce the payments to creditors. But the converse is not true under the statute. If actual income is greater than projected, creditors do not have the right to modify the plan to increase the payments. So if the business does better than is projected, the upside is retained by the business owner. It doesn't go to the creditors. And I think that's very important right now in the situation we are in. Again, to confirm the plan, it's projected net disposable income. But in the situation we're in now, projecting future incomes from a business is extremely difficult. We're in unprecedented times. I don't think anyone can really honestly say they know what business conditions are going to look like 6 months from now, or a year from now, or maybe even a month from now. So any set of projections of net disposable income are going to be inherently uncertain at this point, and businesses may do a lot better, they may do a lot worse. But the upside here appears to stay with the business rather than being available to the creditors. So then the practical side of all of this is, first of all, it's kind of an obvious point, is that cash is king, preserve it. But certainly in the bankruptcy setting, a debtor is only as good as much cash as it has. And the more cash it has, the more flexibility it will have, and the better the outcome it's likely to see in a Chapter 11 proceeding, or even in a small business proceeding. Just much more flexibility if the business has money. Secondly, I think for all business owners, they need to be talking to their landlord, their lender, and their vendors. I probably should put employees in there as well. Their remedies are limited now. You have these emergency moratoriums. The courts are closed, so unpaid vendors can't sue. But they're going to have rights when the emergency ends. At some point, these restrictions will go away, and these parties are going to have rights, and whatever is owed is going to have to be dealt with at that point in time. And so if you're talking now, I think your creditors are going to have more of an incentive to work with you now. First of all, because they likely have others in the same position. If they're a landlord, they have other businesses that can't pay them. If they're a vendor, they probably have other customers who can't pay them. And also, they're going to be experiencing the same stresses. Your creditors have their own set of creditors that they're probably having trouble paying. They've got a landlord, they've got issues with paying. So there's a whole chain here. And so I think a business probably has the most flexibility right now to go out and be talking to its lenders and other creditors and trying to work something out with them on how this is going to be handled between now and the end of the emergency, and what's going to happen when the emergency ends. If parties are inflexible, there's limitations on the ability to exercise remedies, and there's the Small Business Reorganization Act if you're a business that is under $7.5 million in total debt. That does tie in with what Jen said, though. If one takes the PPP type loans, that could get one over the debt limit. And so maybe I actually got asked this question by a client. Do you take the loan, which takes you out of the Small Business Reorganization Act, but then if you can get it forgiven later, you might drop back down under the $7.5 million and be able to file as a small business at that point. So there's maybe a strategy there where one can take the money, and then when it's forgiven, have the ability to drop back into the Small Business Act. So with that, I think my time is beginning to wind up. I'm happy to answer any questions offline. There's my contact information, and I'd be pleased to chat with any of you either by email or in a quick call if anybody would like to. And with that, I'm going to Oops, stop sharing the screen and turn it over to Jeff.